Hello and welcome to Legalese. I'm Ernie Hyde, your host, and we're going to be talking about OUI defenses, in some people's terms drunk driving, or driving under the influence of alcohol or drugs. And I have with me today Christopher T. Lilly. Chris is with the law firm of Lorden, Pastor and Lilly. He is a partner there, and that's in Ayer, Massachusetts on East Main Street. Chris has been on the program a number of times in the past and has hosted a couple actually in the past. And he's a wealth of knowledge when it comes to criminal law and OUIs in particular. He is a former DA from New York City as well as a defense attorney here in Massachusetts. So welcome, Chris.
Thank you, Ernie.
The last program, last month's show, we talked about OUI from the point of view of the judges and the way they see an OUI, and the police department, the way they view it. And this month we're going to talk about defenses and what we do generally as a defense. So let me just start off by giving a little bit of background on what we talked about in the last show in case people didn't see it. But we talked about in Massachusetts there is a per se rule of if you have a 0.08 blood alcohol concentration in your blood, usually determined by a breathalyzer, you are considered to be guilty of operating under the influence. There are ways, obviously, to challenge that, which we'll talk about, but that is one way to show that you're under the influence. The other, of course, is to show that you are driving a vehicle and you are impaired by alcohol or drugs while you're doing that. And as Judge Brooks pointed out last show, you have to be on a public way, and you have to be considered either the 0.08 or operating impaired. So that's how the charge comes about, and we need to start talking about the issues that go with alcohol consumption. Some people feel as though any alcohol is illegal when you're driving. What's your take on it?
Well, and this is part of the instruction that is given by the judge to the jury, is that it's not illegal for somebody to drink and then drive. That's not what the law is prescribing. Excuse me. What is prescribing is the fact that a person has consumed enough alcohol such that their ability to operate that motor vehicle is diminished by the use of alcohol. Now, that's kind of one aspect of what you just talked about there. So we have those two aspects defining the third element. The first element being public way, second one being operation, right, and then the intoxication. Right. Now, the intoxication being established by the two alternate means per se, as is referred to in court, or the common law, which is what it used to be, just the common law prior to the coming of Melanie's law, which did establish the 0.08 as being a way of establishing that third element. So if a person has the 0.08 in their bloodstream, that is considered against the law. If a person's ability to operate, regardless of what that amount is in their bloodstream, their ability to operate is diminished by the use of alcohol, that is considered against the law. Right. So it's not just the drinking and then the driving. You have one beer or whatever it is, and you go out and you drive and you're not diminished and you don't have a 0.08 as a result, you are not breaking the law.
Okay. And by the same token, when we're defending an OUI client, it really isn't the amount of alcohol they had to drink that is the primary factor in whether or not they are impaired in their driving, right?
It is and it isn't. I mean, that's not an element that needs to be established by the Commonwealth, that a person had certain number to drink.
Right.
It is what, as I said, the effect is on that individual. Now, a certain number that a person may have to drink when considered with some of the other factors of a person's height, weight, what they had to eat when they last had a drink, all of that goes into effect in determining what a person's likely to have as far as a blood alcohol concentration.
Right. Okay, so not only is the amount of alcohol that you consume important, the amount of time that you had it in, your size, actually whether you're a man or a woman is also important, and what you've had to consume for food during that period of time, or at least leading up to
and the timing of it as well. So if you had a lot to drink some time ago, you stop drinking, and then you're driving, that is going to be affecting what you have in your bloodstream at that at that point that you're driving, and it's really the point that you're driving is the issue. So a person is stopped; they're driving a vehicle. They're stopped. They're made to go through field sobriety tests. There may be some further delay. They may be taken to the police station. Maybe that breathalyzer isn't working. They're taken to another police station. Time goes by, and you come up with a score, perhaps, on a breathalyzer, which is supposed to be extrapolated back to the time period of the stop, because that's the time period that's really in question.
Right.
And that's part of what we can look at the time of trial to determine if, in fact, that's really a realistic. Well, it's a realistic number, but is that really a true number of what that person may have had in their bloodstream? So, for instance, a person drinks a lot just before jumping into the vehicle. That the bulk of their drinking is just before they get into the vehicle. So now they have a stomach full of alcohol. I have an expert who refers to the alcohol in the stomach alcohol, as being the same as alcohol in the glass. It's really not in your bloodstream at that point.
At that point,
it's still in your stomach, and it does eventually get absorbed from the stomach into the blood.
Yep.
And that's what we're looking at to try to determine whether a person is intoxicated and what that blood alcohol content may be.
Right.
So there are a number of factors that come into play.
Right. Now, what I have studied on this is the fact that you'll find most studies have indicated that absorption takes place with alcohol at the rate of 0.02 blood alcohol content per hour. And it metabolizes or eliminates alcohol at a 0.015. So doing the math, you can figure out how many you've had to drink and over what period of time you're going to need to have all of that alcohol out of your system.
That's a nice, neat way of saying that, well, gee, I guess I can figure out just by that simple math, but the math isn't really simple, because there are a number of other factors to the equation that we've just gone over.
Right. Size,
weight, what they had to, when they first started, when they last had their drink, what they had to eat, what else is, you have something else in your stomach, that's also absorbing the alcohol, not into your bloodstream. So it's hard to say.
Yep. I have noticed, though, over the years that clients come in and we start talking about, and this is before I see a police report, of course, and we start talking about, well, how much did you have to drink? And they say, I probably had 2 or 3 beers. And you say, well, okay, well, sounds like you got a reasonable case. And then you get the police report and it says 0.16 for a BT level. That's impossible. It's impossible. No matter how small you are, whether you had nothing to eat, 0.16 over the time period that they talk about is impossible. And people ought to be a little bit more honest, if they know what they had to drink, when they're talking to someone who is going to try to defend them in either a trial or a plea.
Well, I mean, talking to your own attorney, that's protected by attorney-client privilege.
Right, exactly.
It certainly is in your best interest to lay out exactly what the situation is, so
Right.
that attorney can use that information as it is best used.
Yep. Yep.
Yeah, you certainly don't need surprises, and particularly not at trial.
The other thing we should get into right away is possible defenses for the charge of OUI. I think it's safe to say that there are some exceptions on both sides of this fence, but if you are truly intoxicated, it almost doesn't matter where you try it, how you try it, in front of who you try it. You're probably going to be found guilty. As I say, exceptions on both sides of this case. But if you're not, the chances are pretty good that you're not going to be found guilty. So the question is, what's the first step in your mind when someone comes in and talks to you about an OUI and hires you to do a defense of them? What are you looking at first, especially if you have the police report in front of you? What are you looking at first?
Well, you certainly begin with the three elements and determine if on the face of the police report. Now, I tell my clients that the police report is a nice view of what the Commonwealth's evidence is going to be against you,
Right.
because it's likely to be what the officer is going
Exactly.
to testify to. So you look and see first, have they made out the case. I also look at it. So I look at it from that point of view and what my defenses or what the possible defenses are going to be at trial. But I also look at it from the point of view of not just at the trial stage what can be established or defended, but prior to the trial stage. There are some things that, first of all, I want to be looking at. I want to look at this breathalyzer. I want to determine if things were done the right way. Sometimes there's a booking video. You want to see if the officer has been observing the individual.
Correct.
And determine if they observed them for a 15-minute period immediately prior to blowing into the breathalyzer, because that's what's required by the law.
Mm-hmm.
You want to be looking at prior tests and determine from there, maybe it's running a little high, maybe it's running a little low, but you also want to be looking at the simulator, which is supposed to be a constant, to determine if, in fact, it is scoring at the level that it's supposed to be scoring at. There's a lot to be looking at with the
Right.
breathalyzer.
Right.
I actually had one situation where a breathalyzer came back. This is under the older system, where it came back. It's supposed to come back with a temperature. The temperature was actually registered as NA. They weren't giving the temperature, which was a big issue at the trial in terms of knocking it out, because temperature is a
Very important
crucial
factor. Yeah.
crucial
Right.
factor
Right.
in determining what that blood alcohol content should be.
Right.
So that's part of what I'm looking at, but I'm also looking at the stop of the vehicle. What the officer saw prior to initiating the stop of the vehicle, and determining if, well, did he have enough information, reasonable suspicion, to pull over that vehicle, that the vehicle is either is engaged in, has been engaged in, that the operator of that vehicle is engaged in a crime, giving rise to reasonable suspicion to pull them over and conduct their investigation. And a lot of times you find out that the answer to that question may be no. And that is certainly a valuable item to be looking at, because it really doesn't hurt the individual to take this to a motion to suppress
Right.
the stop, because you don't have the risk. They're not receiving the risk that you would have at trial.
Right.
at the hearing stage. So it's always worthwhile to be exploring that.
Right. So some of the things that police are looking for, and actually in our show last month, Judge Brooks raised the issue of running number plates, which, if people are not aware of this, they should be by now. But police have onboard computers in their cruisers, and they have a tendency to roam through parking lots and enter registration numbers off of plates, which they are entirely in their right to do. It is not illegal. It is something that is condoned. It is a public number, and you have it displayed there. And the registry comes back and says whether the license is suspended of the driver, or if the registration is canceled, or if there's no insurance on the vehicle, or so on. So if you're going to go out and party and you're going to drive your car home, you want to at least know that, one, your license is still in effect, and two, you have a registered car that is insured in Massachusetts, okay?
But also that the owner of that vehicle's license is in effect, because that's a legitimate reason to pull somebody over as well.
Exactly. However, that's also, in some cases, a defense where the registered owner is John Jones, but you got a female driver. So now you got the question of, was that a legitimate stop, knowing that John Jones is the owner and that license is suspended, but the driver was a female. So those kinds of issues come up all the time in these cases.
I love motions to suppress.
Yeah, exactly.
Excuse me. I've had those issues come up, and yeah, that absolutely can be a reason. Maybe they have a reason to pull them over, but once they realize that, okay, this person does not match the description of what the owner of the vehicle looks like, they shouldn't engage in further discussion. I've had officers that do engage in further discussion.
Ask people to step out of the car.
That's determined to be impinging on the liberty of that individual, and therefore it's impermissible at that point. Even when they're not being asked to step from the car, they're not supposed to engage them in any kind of investigative inquiry.
Right.
Now, that being said, certainly the officer is the king of the road as far as when he has you stopped, and you don't want to be arguing back with him about what you can do and cannot do. But there may come a point when the officer asks you to step from the vehicle and perform field sobriety tests. Now, that officer doesn't tell you you have a right not to perform field sobriety tests.
Right.
They don't have to tell you that.
Right.
But there is no obligation for you to perform a field sobriety test. I mean, you certainly want to be polite, but as I said, that's not something that you're required to do at that point.
Right.
And if there is the further force, ordering somebody out of the car, taking them into custody, that kind of ratchets the situation up a little bit as far as further intrusion into the liberty of the individual,
Right.
to the point that it may become or be deemed a full-blown arrest. And then you got to be looking at more than just a reasonable suspicion. You got to be looking at probable cause.
Right. Yeah, it's really good advice that you give when you say, be polite, be respectful. These officers out there are just doing their job, and they're doing it for your protection, my protection, the driver's protection, and so on. But you have certain rights, and you ought to be aware of those rights. And the rights include not doing the field sobriety test and not taking a breathalyzer. Now, one comes with a penalty, one doesn't. What about the breathalyzer?
There's no built-in penalty for refusing to do the field sobriety test.
Correct.
But the officer may very well make his decision or her decision at that point that I'm going to arrest this person. Now, you haven't given them the evidence that they may intend to be introducing at you at trial when you do the field sobriety test, but there isn't that built-in penalty as there is with the breathalyzer. So with the breathalyzer, and that depends on the number of OUIs that a person has in their criminal history.
Right.
If it's your first offense OUI and you refuse a breathalyzer, you lose your license for a period of 180 days.
Correct.
If you have one prior in your past and you refuse to take the breathalyzer, you lose your license for 3 years.
Right.
Then it goes up from there.
Now, again, I want to emphasize this is Massachusetts law. So
Massachusetts,
if you're looking at this program outside of Massachusetts, it may not apply to you. But yeah, that's right. And if you take the breathalyzer and fail it as a first-time offender,
you lose your license for 30 days.
30 days. So significant difference incentive there.
Difference, and incentive is the right word. It's an incentive that's being built into the newer law that is designed to get people to take the breathalyzer because they want people to give that evidence that's going to be used against them. So the question of, well, gee, should I take the breathalyzer, certainly becomes harder to answer. Once upon a time, knee-jerk reaction, don't take that breathalyzer. From my perspective, I still say don't take that breathalyzer, but there are significant consequences to not doing so.
Well, there's a lot to be said, though, for someone who gets stopped and says to the officer, thank you very much for the opportunity to do the field sobriety test, but I choose not to do that. Yeah. And by the same token, I choose not to take a breathalyzer. And at that point, the only thing the officer really has is observation. I won't say it's impossible to convict on observation because I'm sure you've seen it, I've seen it, but it's not likely. It's pretty unlikely for the most part.
The observation, now you're talking about the
I'm not talking about
law.
weaving all over the road. I'm talking about a stop for some reason other than weaving all over the road. I'm talking about maybe a license plate issue.
But even the weaving all over the road, there can be explanations for why a person is coming across the way they're coming across to the officer. Right. So the officer is trained to have, I refer to it as a checklist of items that they refer to. Bloodshot, glassy eyes, unsteady on their feet, red face, the odor of an alcoholic beverage emanating from their breath or person. All of these are items that they bring up to support the opinion that they have established and will establish at the trial that they believe that this person is under the influence of an intoxicating beverage. Right. But a lot of those things can be brought into question for the jury.
It could be caused by other things, sure.
Why does a person have bloodshot, glassy eyes? Well, maybe they've been smoking. Maybe they've been crying. Maybe it's late at night. Maybe some people just have bloodshot, glassy eyes. Flushed face, same type of situation. Right. The odor of an alcoholic beverage. The fact that there is that odor, it's not the alcohol that you're smelling, it's actually the chemicals or the ingredients that accompany the alcohol, such as the hops and the barley of the beer. Right. Right. So you're not actually smelling the alcohol, you're smelling something else. So really if it's a strong odor, that may be an indication that they've been drinking something that's actually lesser, containing lesser alcohol than, let's say, vodka. So there's a lot there that can be delved into.
Okay, as far as the portable breathalyzer, we talked about this during the last show as well. It can be used, as Detective Luppold pointed out in that show, that it's sort of used as a jump ball. I'm not quite sure that I want to arrest this person for OUI, but it's a pretty clear indication to me if I get a portable BT of a 0.14 that I'm probably right about my observations. You agree with that? Even though it can't come in as evidence, we all know that.
I agree that it gives support to an arrest. The fact that an officer may be looking at it as a jump ball, the officers, I think, are trained to say that after they've conducted each and every field sobriety test, that's when they make their
which is usually when they do it.
That's when they make their opinion. That's what they say. And that's part of our job as a defense attorney is to look at it. Well, gee, is this really a rush to judgment? Have they already made their mind up? And they're just kind of going through the motions at that point and gathering evidence that they want to introduce with that skewed eye toward kind of bolstering their opinion. So a jump ball, I don't know if that's, obviously every case is a little bit different.
But it's usually given after all of those.
It's usually given at the end, and I would suggest that it is a way of establishing probable cause. If somebody blows into that and they have more than 0.08, you've essentially established the probable cause.
Right. Even though they can't use it as evidence. Right. Exactly. Okay. Let's talk briefly about the breathalyzer because we're going to be running out of time. There are several ways to challenge the breathalyzer machine itself, but more importantly, I want to talk about things like test failures. In other words, you have someone who is asked to do a breathalyzer and they say, yeah, I'd be happy to, but they can't
Right.
for all kinds of different reasons. How do you address that?
Are you talking about from the point of view of whether that's deemed to be a refusal?
Correct.
Okay. I have seen that come up in the past where a person is deemed to refuse because they've attempted to blow into the breathalyzer and have, in fact, been unable to do so, and the officer thinks that the person is just playing games. And that does end up going through as a refusal, and it goes to the Registry of Motor Vehicles as a refusal. And once you get that suspension, you should be getting notice from the registry, and you got to make sure that they have your correct address at the registry. You get that notice, and they tell you to that you have the opportunity to have a hearing on this matter. Go to 630 Washington Street in downtown Boston, which is the only place in the Commonwealth you can go
Which
for
is
these.
just a lovely place to get to,
That's
yes.
all right. And you can contest it, but what they're going to want to see is something from a doctor
Showing that you
says
couldn't have
that I can't get the breath up, or I've got this problem, or
emphysema or
yeah.
something along that line.
something that physically makes it so that I cannot do that.
Yeah.
And that can be tough as well.
Yeah. One of the things I wanted to bring up, because you did mention it regarding the refusal to take a breathalyzer, is that it depends a great deal on how many OUIs you have in your past. In Massachusetts, that is a lifetime past. So
Yes.
before, we used to be able to look back, or the Commonwealth would look back no more than, what was it, 6 years at the time, I think it was?
10 years.
10 years at the time. And so if you had 50 OUIs before that 10 years, they didn't count. Only the ones in the last 10 did. Well, now it's,
50
but
seems
50
like a
count
lot.
as well. So people should understand that if they ever had an OUI, the next time is a second and a third and a fourth, whatever. And the penalties we went over briefly in the last show, so we won't bother doing that. Quick answer. Do you normally go jury trial, or do you go jury waived, which is with a judge?
It depends.
I knew you were going to say that, so now
It
answer
depends
why.
on a number of factors. Not the least of all is who's sitting that day.
Yeah, right.
Um,
Well, of course.
And there are certain cases that you feel may have more of a legal issue that you want to take before a judge.
Technical issue.
Technical issue or
Yeah.
a legal issue that you
Yeah.
want to take before the judge. Maybe you've got something more sympathetic, but legally it may not be going your way. You want to take that to a jury. So there are there's some strategic planning in deciding that, and that's all part of
The strategy.
the strategy and part of the charm of going to trial.
The charm, yeah. Well, Chris, I want to thank you for coming on. As usual, you've been insightful. And I think the best advice we can give anyone is to not need our services for this, because if you don't drink and drive, or if you drink very little before you drive, you might not ever get into a problem. The idea is to stay out of the problem before you get into it, and you won't need our services in any case. Again, thanks for coming on, and for those of you out there, Legalese is brought to you by the Northern Middlesex Bar Association on a monthly basis. And I want to thank you for watching, and we'll see you again next time.